Welcome to Module 1. Here I'll be letting you understand the importance of a contract in the various transactions you'll be having in your business. But first off, we need to understand what a contract is. So a contract is pretty much a document, an agreement between private parties that stipulates mutual obligations and it is enforceable by the law. For a contract to be legally valid and enforceable by the law, it must have an offer, an acceptance. There must be a valid consideration, a mutual assent, capacity. So both parties must have the capacity to enter into that contract and it must be considered legal. There are contracts that are considered illegal, and if you have them, they will be considered void, like it would not hold any ground anywhere. So it's important that you understand that your contract has to be legal for it to be valid. So now we're just going to go into the importance of a contract. So once you have a contract in a transaction, there are a number of things that you will prevent, and it's very beneficial to your business that you have a contract. A contract provides certainty in the sense that you'll be sure of what you're getting into. It will be clearly stipulated that, okay, this is the business, this is the value exchange, this is what we're doing, and you're clear, basically. So there you have certainty. A contract is a record of rights, responsibilities, and obligation. You have it as a record to always go back and say, oh, party A, you said you were going to do this. Please or kindly deliver on this. It also prevents disputes. Because of how clear contracts are, there are a number of disputes that you would prevent. There are a lot of disputes that you prevent because the terms are clearly stipulated. And even when a dispute arises, the contract equally provides a due term, like a due clause, which states, okay, this is how you're going to resolve the issue. Last but not the least, a contract will ensure that you get paid because it is stipulated there, the date, the time, the amount, and it would always hold ground. You just have to understand your rights when it relates to a contract. So now we're on the steps to take before signing a contract. This part is very crucial, and please listen, it's very, very crucial. So at this point, you need to read every detail. If you don't understand a particular term, if you don't understand something, you need to be clear on it before putting your signature, because there have been several instances where people just sign and the next day you're like, oh, this is what this meant. Don't be in that situation. You got a deal, you're excited, you're so happy that you got that deal, and the next thing for you might be, oh my gosh, I just want to sign. Calm down. Your work is good. That is why you got the deal, right? So just calm down a bit. The opportunity would not pass you by. Tell them you have to read it and you have to review it by your lawyer. And when you say that, make sure that it is reviewed. So you need to know your rights and you need to understand your duties. So if you're entering a contractual relationship, you need to understand what your rights are as it relates to that exchange, as it relates to that business or the transaction. You need to understand your rights, you need to understand your duties. And there is a clause that stipulates the rights and the duties. So please don't ignore any section, don't ignore any line. Read it all, because the other party would hold you accountable for anything that you agree that you will do. So it's important that you understand your rights and your duties. Next off, if you have a correction to be made, like if you notice something in the agreement in the reviewing stage and you want this thing to be changed, it is important that you ensure that it is changed. Once you have your lawyer review it and you notice that, okay, this is a problem in this agreement, speak to your lawyer and ensure that that aspect is reviewed. Ensure it is reviewed, because it can be reviewed, you've seen it, you've seen that, oh, this is an issue, and you've sent it to the other party, but it was not changed. You would not check it again, or maybe you fail to check it because you feel that, okay, you've pointed it out and, oh, they know now, they might have changed it. You have to go over the agreement again to make sure that what you said they should change has been changed based off of the agreement. So this is very, very important. Don't make the mistake of, oh, I reviewed and I failed to recheck to know if it has been changed. So there's several laws that cover different transaction. We have the Companies and Allied Matters Act that cover commercial law issues or corporate law issues. So in that instance, this should be stipulated in your contract. It should be stipulated as the law that will be guiding your contract. Then also we have the jurisdiction. It's important that your jurisdiction is clear. Some people draft contracts and their contract is, I don't know, like Kenya when they are in Nigeria. So it is a bit confusing. You need to make sure that that area is clear. And if it is a contract between different companies from different nations, at that point, both parties will decide where is most suitable for the both parties. So it's important that you take note of this, take note of the laws governing the contract, and also take note of the jurisdiction, right? Then next thing, you need to review the termination clause. Every contract should have a termination clause. This prevents, like unnecessary discussions in the sense that, if you no longer have an interest in doing that business, it is stipulated in the contract. It is stipulated clearly, okay, this is the due process, this is the amount of days that is required for you to make a notice before you end the contractual relationship. It is stated. So it's important that there is a termination clause. Look out for a termination clause before you sign. Look out for the days and say, okay, these days, does it work for me or doesn't it work for my business? You have to think this way, right? Then also there is the confidentiality clause. What you're sharing with a third party or what a third party is sharing with you, it is confidential. So at this point, you need to look out for it. Look out for your own interest to ensure that your interest is protected as it relates to confidentiality. Above all, you need to seek professional help because in reading or reviewing a contract, there are a lot of terms that you would not understand or you may not understand. There are terms which you might not, have a clear perspective towards. So at this point, it's important that you hire a lawyer or you seek the help of a lawyer to review your agreements. It is only to your own interest, to your own good interest. And lastly, to prevent the had I known, to prevent all those statements, it's important that you start reviewing your contracts with a lawyer before you take any other process. It's important you have this knowledge, but it's also important that you speak to a lawyer. And if you have any issue, the lawyer will put you through on the right steps to take. So now this brings us to the end of module 1 and we'll be jumping right into module 2. Stay tuned again.